SJC-13217, Commonwealth versus Joshua Hart.
Okay, Attorney Maidman.
Good morning. Please the court, Stephen Maidman for Joshua Hart, the defendant. This case is primarily about whether the defendant's confessions were involuntary. I'd like to focus on that, and then I'll address the spontaneous utterances issue, and I'll rely on my brief for the remaining two issues. With respect to the confessions, the record. This is a case where you have two recorded confessions, one by Virginia sheriffs and one by the Massachusetts State Police. So the record is clear what was said and wasn't said during the interrogations. The defendant was looking for a deal, and he thought he got a deal. His deal was, I'll tell you everything about what happened. You get protection, to use his word, protection for Ms. Smith, his girlfriend.
And you're right. The record is clear about what was said and what was not said. And we've all read cases and know cases that in a continuum, this doesn't seem to even come close, because they continue to say to him, we don't have authority to do anything. We don't have authority to give you immunity. We don't have authority to give a deal to your Confederate. We can't do anything. The only thing you can do is tell us what you know. So when you look at the transcript of the interrogation, help me understand at what point the Q&A specifically that they say we're going to give her a deal if you talk.
Well, let me first address the first part of your question. They didn't say you don't have a deal until the end of, in the first confession, until the end of the statement, and it's in my brief. Everything's either in the brief or the transcript. They said you can try to work a deal with that, though. I won't discuss deals. That was at the very end, after he spilled his guts. Okay.
Well,
When was the deal struck?
The deal was struck within the first couple minutes of the interrogation. It's on page 29 of my brief, or 54 of the record appendix, page 7 of the original transcript. And the words, I quoted it because it was, when I read this, I was struck by it. It says, and this is the Sheriff Funkheiser, and all I can tell you is the only way you're going to protect her and protect her soul, and that's the religious issue, and her well-being, and everything else, is for you to be upfront with us and candid and take advantage of this opportunity. So that's the now or never claim. Because if it's something you feel strongly about and you're given this opportunity to speak freely and you don't take advantage of it, you know, we don't want her to, you're telling me that you don't want her involved. I want to take your word at it, okay? And he answers, because she wasn't. You know what I mean. It wasn't supposed to happen like that and stuff. So that's why I said, do you think after we talk, there's a way we could try to contact the police department down there and arrange something? And the sheriff answers, if you're honest with me and you're telling me everything that's going on. Defendant says, all right, thank you. And then to emphasize it further, or to encourage the defendant further, the sheriff goes, certainly we're talking with the police department from Massachusetts now. Defendant goes, all right, thank you. And they want your cooperation. If that isn't a deal, I mean, maybe not pure offer and acceptance for the bar exam, but it's pretty close, in my view, and I would suggest the court look at it that way. The person, especially look at it from the defendant's standpoint. This guy, after hearing this, he thought he had a deal. And that's what the record says.
Well, I know there's another side to that, but the point, I guess, I keep coming back to is it seems pretty clearly that this defendant was looking to protect his girlfriend, his Confederate, his co-defendant, what have you. That Again, going back to the cases that inform some of our analysis, this isn't one of these cases where they seemingly had to pull teeth. This person seemingly came in saying, I want to talk because I'm motivated to protect my girlfriend here. So can you at least give me, if you could give me this, is the entire voluntariness of the Massachusetts interrogation, does it rise or fall on whether or not the interview with the sheriff was good or not?
No. And the reason I say that is that the Massachusetts sheriff, the Massachusetts state troopers, they knew what happened in the first one. They had the tape recording. Whether they listened to it or how much they listened to it, it's unclear in the record. Okay, but they knew what went on. Okay, and they certainly didn't say, we understand that the sheriff said blah 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 to you, and I want you to know we're from Massachusetts. We're not giving you a deal. You have no deal. They should have told you you don't have a deal. They shouldn't have said this. That never happened.
Is the cat out of the bag based upon a time lapse, or is it based upon correcting the record? That's what I'm
sorry, Jessica.
Yeah, we have the cat out of the bag.
Yes.
That's what you're referring to
Yes,
with the state police, Mass State Police, and there's a 24-hour, almost exactly delay between. And on the case law, what you found, Mr. Mayman, is the cat out of the bag analysis based upon a temporal break, or is there?
No.
Please
It's not.
explain.
That's the break in the stream of events test.
Yeah,
the
please
cat out of the bag is actually originated in the federal system. And Massachusetts uses both tests. At least that's what it looks like from the case law. First question, was there a break in the stream of events? Did he talk to a lawyer? Did he talk to his friends? All that. There's nothing in the record to even suggest that. This guy was held incommunicado. Same jail, same everything. Okay? And whereas the cat out of the bag analysis, is did he think that was it futile for him to withhold evidence? Did he have anything to lose at that point? This guy, this is in the record, he was interrogated by the Harrisonburg Police Department for mugging someone at a mall, okay, to get money. And he told the Harrisburg Police Department, I'm going to jail for murder.
That's okay. So we have the Virginia County folks.
Yes.
Do the soul.
Yes.
Protect your soul inquiry.
Right.
Then we have a interview by the locals for a mugging.
For not in the for a mugging, he ripped off her purse.
Right. And then we have the state police, Mass
State Police 24 hours later.
Okay.
They come down and they get pretty thorough. And this guy, and by the way, there were additional facts given to the Massachusetts State Police. I think it's reasonable person looking at the record is going to say, this guy spilled his guts all over again and more.
Where does it go in and I read Judge Agostini's opinion, but where does it go in the overall voluntariness inquiry, which is something Justice George has referred to, where was his will overborne, essentially? So we have someone who wants to cooperate.
Well, his
right, and then like I'm thinking of the classic cases Novo and some of the other cases where they basically said, hey, you're going to lose your kids, that type of coercion.
The record is clear. He wanted to confess for the deal. I don't think the record is so clear, and I don't think this is reasonable interpretation. I'm here. I need to confess. Period. Okay. I'm here because the reason I want to talk to you is to get protection from my girlfriend. I think that's what the record says. And the other one last point on this. This court has warned the police, don't bargain with defendants over releasing loved ones. Okay, that's relatively clear. The case is.
Our case law is a little strict because we say some trickery is okay.
Oh, we definitely say
there's a lot of fluff in the standard as far as coercion.
No, you're absolutely right, Judge Gaziano.
Minimization, etc.
It is.
Minimization is bad until we say it's not bad.
Yeah, that's correct. But this was That's why, we can talk about protecting your soul, we can talk about now or never, we can talk about all these other things that went on, other bad things that went on, but it comes back to that this defendant thought he had a deal.
But that's why you.
the argument.
That's why you focus more on the deal rather than the religious
Yeah,
stuff,
I mean,
and then
I mean,
the minimization and the now or never.
the Judge Agostini, you're in the same position as Judge Agostini, in my view, except for the religious stuff, because he questioned him at the motion hearing, and he said, I find Sheriff Funkhauser credible. Everything else, you're in the same position. I would suggest the record. You can make your own conclusion. But I think that's pretty much what I wanted to say about the Virginia confessions. Unless the court has any questions, let me just 1 second here. No, I think I covered it. That's the argument. Now, as far as Ms. Fisher's statements to the healthcare workers, but let me begin. This was a terrible crime. Okay, I don't want to minimize anything. But the question of excited utterances, if this court goes along with 12 hours from the event, this court is dramatically expanding the law of exciting utterances in the Commonwealth of Massachusetts. I put a...
Doesn't it go hand in glove with the first issue? Because given the amount of evidence in this case, as far as prejudicial error goes for excited utterance. Even if we, if we agree with you,
Yeah.
frankly.
If the confessions come in, then why are we talking about excited utterance? Of course.
Yeah.
But on the other hand, this is 12 hours. I found a footnote in Mass Practice which lists 5 minutes, 5 seconds, and nowhere near do we get to 12 hours.
There's a DC Circuit case, though, that says 11.
Okay. I mean, I didn't find that one.
Well, it's cited by your opposing counsel. That's how I found it. Not that good.
Okay.
So.
But the point is, the victim in this case was brutally mugged, attacked, and she's been on the floor in various states of conscious. I mean, I don't want to minimize that. She was in bad shape, but to say 12 hours later she couldn't reflect on what happened I think I just don't think that's what the hearsay rules are all about. But then you get to the second part, the second test, whether it was testimonial. Okay. First, we get the Massachusetts State hearsay law. Then we get the Crawford analysis,
But on the confrontation analysis, in looking at what when we look to as a substitute for trial testimony, taking what you have said a little bit before, this was an awful, brutal, vicious attack. Where an elderly woman in her home was there alone, suffering from these injuries. And so when we talk about why it is that we look to the substitute, do you think she's really thinking and deliberating about preserving testimony down, or that she's still suffering from these awful injuries when a healthcare worker comes in and asks her what happened?
I think she's really saying, this is my personal opinion. I'm inferring it from the record. I guess I don't agree. I agree with you. I think she was reporting what happened for the purposes of seeing her assailants brought to justice. That's my reaction to it. It certainly can be read that way. And again, we're looking. It doesn't matter what she's thinking. It matters what the objective listener would perceive. She certainly was not. She certainly wasn't saying, "I need help." The ambulance is already on the way.
Well,
this is not like the 911 call. Send me an ambulance.
I think we're looking to when you look at the objectivity of it. She had crawled out on the porch. She had yelled out for help. No one had come. She'd come back in. Again, I'm just trying to look to the lens of how somebody that's in that in those dire straits would be thinking, I'm trying to preserve testimony down the road, as opposed to, I'm just trying to stay alive.
Yeah, I don't think she thought about preserving testimony. I think she thought about, this is what the guy did to me so the cops can prosecute him. I don't think in terms of, this was not obvious, and also these were not police officers reporting to the healthcare workers.
Sure,
Okay.
but that also cuts against you, doesn't it?
Yes, it does. But still, it's if I'm reporting, this is what these guys did to me. It certainly sounds testimonial to me. But that's the issue. You had that's the issue. But again, if it doesn't pass muster under the hearsay rules, you never get to the second. You never get to the Crawford issue. So. I get it's just again. I would emphasize that this court needs to look at how this potentially could change the law in Massachusetts. And I don't think it's I mean, every time that this court has addressed, or trial judges, in my experience, have addressed, or you addressed when you were a trial judge, it's the first question in mind is, well, how many seconds later was it? This is not seconds. This is hours. So unless the court has any further questions on that, do you question? No?
I don't know.
Okay. I guess the only thing I'd mention one thing about the venue. These were very prominent citizens of the community, no question about it. I'm not sure whether every potential juror in the veneer knew about it, but they certainly, this was well known in the community. And Judge Agostini took the position, well, I'll try to seat a jury. Well, you know, there's the question is, you know, is there taint here?
This isn't much different from the co-defendant case that we decided.
Well, yes, and I don't want to get that co-defendant case theoretically is not in the record, but I'm aware of it, obviously.
Well, it's precedent.
Yeah, it's precedent, but in that one, they had all the publicity from the first trial, from this case. This guy didn't have this, but when this happened, this was a major news event in Greenfield, Franklin County, Massachusetts. No question about it. And the jurors all knew about it. And unless the court has any questions, I rest on my brief.
Okay, thank you. Okay, Attorney Von Flattern.
Good morning, Chief Justice, members of the court. Cynthia Von Flattern for the Northwestern District for the Commonwealth. Turning back to the first issue, the Commonwealth would submit that this court should find, as the motion judge did, that considered in the totality of the circumstances, the defendant's statement to Virginia sheriffs and to state police, that they were both voluntary in the totality of the circumstances. The defendant came into the interrogation room in Virginia saying he wanted to give details, he wanted to make a statement. They attempted to give him Miranda warnings. It was as the judge found, conversational, cordial. He was treated with the utmost of respect. He knew the Miranda warnings, and he recited them for him, to them. They gave them again, of course. And then there was this issue. He sets it up, and he says he is looking to make a deal. The police officer, or the sheriff, summarizes what he has said, because the defendant is talking about how much he cares for the co-defendant. He doesn't want to see her get in trouble, and he summarizes that statement. And then he does have that one paragraph where he is encouraging the defendant to speak, and he says, we'll let your cooperation be known to the authorities, to Massachusetts authorities, and he's definitely encouraging him to speak. He also says, well, this is your chance to talk. And so, of course, there's case law about the now or never. Did you set up now or never? But that wasn't the case. He just encouraged him to speak. And in fact, the defendant knew that he was going to have the opportunity to talk to the state police. So, and then with respect to the comment that the sheriff made about encouraging the defendant to speak to help the co-defendant's soul, the Commonwealth would submit, as Judge Agostini found, that when he said soul, he was not referring to, in a religious sense, to the co-defendant's soul, but really to her person. After all, this was a woman who was still alive. It wasn't like she was the victim and deceased, and he was really referring to, in order to help the defendant. There was no other talk about the defendant's religiosity in this interview. And actually, the state police asked about whether he was religious. And he said, no, he wasn't religious, but something about, he thought about going to the church to get help because his grandfather had done that one time, because they would give you food or something like that. But it was clear that the defendant didn't have an attitude that he was particularly religious when he talked to Virginia authorities. But what was especially clear, as this court can see, is that the defendant was very interested in having the co-defendant get the best deal that she could. And his statements tried to minimize her participation and put the onus on him. And of course, the onus did need to be on him a lot, but it also she was also a very active co-defendant in this, and that came out a little bit more in the 2-hour interview with Mass State Police, as they said, okay, now let's go over this again, and let's really hear the truth on some of this. And that was the time when he then did admit that there was a joint intent here to break into the home, to case the home, and to break into the home, and that Ms. Smith, the co-defendant, was very involved with assisting the defendant with the murder of Mr. Hardy, and also committing.
I'm sorry, is your position that there was no deal in Virginia?
Yes, the position is that they said
your
that
opposing counsel read us snippets of that transcript. Why isn't that a deal? I want to protect Smith. Will you help me? And they essentially say, if you tell us the truth, that's the way to go.
He, who is an experienced person with the criminal justice system, says he wants to make a deal and protect her, and they encourage him in that. But they don't say they don't in any way coerce him into that deal. He wants to talk, and they don't.
So your position is there was a deal?
No, my position is not that there was a deal. They're encouraging him, but they don't make a deal. If you just tell us, we'll do this, or if you don't tell us, we won't do this. They merely, when they came into it, they were trying to just get the lay of the land with him, and he explained to them, I have this warrant, but he thought the warrant was about stealing the grandmother's car.
Counsel, can I just interject to follow up with Justice Wendland, because Attorney Maidman read this, and I want to reread it to you. You know what I mean, it wasn't supposed to happen like that and stuff, and so that's why I said, do you think after we talk, there's a way we could try to contact the police department down there and arrange something? That's his question to the sheriffs. And they respond, if you're honest with me and you're telling me everything that's going on. He responds, all right, thank you. They respond, certainly we're talking with the police department from Massachusetts now. He responds, all right, thank you. And they respond, and they want your cooperation. So yes. Again, to your opposing counsel's point, it's not like it's an explicit bargain for exchange, but doesn't this come really, really close?
I think that the language, and it is only on this page of a 58-page transcript that if you read it with not in the totality of the circumstances, I think that they are very encouraging of him, and they want to tell him that they want him to cooperate, or they want him to speak, and that they are going to convey that.
But if you are looking at the totality of the circumstances, and you're somebody that is laser focused on protecting your girlfriend, and you're listening for the lever to be pulled, and you hear that, even if there's another 50-something odd pages of transcript of this back and forth, wouldn't that be the thing that all he's listening for is that's all he needs?
I think again, you can't. we can't take it out of the whole context, including how they're treating him, his condition, which was not on any drugs or alcohol, not saying that he's hungry or tired or anything. They're offering him food, they're offering him water. I think in all of that, he's ready to speak, and he wants to be in control of the situation, and they are encouraging him.
Does the totality help you when the statement, we don't have the authority, is at the very end after he's already confessed?
Well, I don't think that it necessarily helps the Commonwealth when it comes at the end of the statement, but I don't think that, again, that there was no, they are encouraging him, and they did tell state police that he was cooperative, and state police say to him, they've told us that you've been cooperative, and he was treated well by all of these police.
I get what Judge Agostini found, and he said this is an inquiry about whether his will was overborne, and here's somebody who wants to tell a story.
Right, right. And they're not going to dissuade him from that. And again, they're coming into it, they don't really know, and he knows that they don't even know what it's about. And you know, they say, well, there's a mistake. Well, he says, well, this is more than a mistake. So he is ready to speak with them at that point. And you know, he also knows, they've told him it's going to be recorded. He knows that his rights are being protected, and that and he can see that they're not overwhelming him.
Except he's doing this all on account of his girlfriend, right? So yes, he does want to talk, but the reason, his motivation for talking is to protect his girlfriend.
Well, that's certainly a big motivation, and he states that. I think I would submit that a motivation is also that he is aware of how much evidence there's going to be. Maybe not all of it, but he is aware of what was done, and that they used those credit cards, that they stole the victim's car, that there are forensics. He knows, he mentions, he knows there's going to be fingerprints, he knows there's going to be DNA in the house. And so it also is, I would submit, he feels going to make it easier on him, because he already recognizes how much trouble he's in and how strong the case is.
So then going back to Justice Winland's question, was there a deal in Virginia?
No, I would say there was clearly no deal.
But did he think there was a deal in Virginia?
No.
He didn't think there was a deal.
No, and he didn't have a deal with the state police either.
Yeah, what about the whole cat out of bag, breaking the action analysis? Can you explain that to me, please?
Well, I would submit that there's no concern if the first statement, and which I would submit is perfectly voluntary, and with the second statement, again, if he knows that his statement hasn't particularly hurt him because of the weight of the case against him already, and that he has spun it in certain ways. There's certain things that he said that the Commonwealth would show were not true, that would make it seem like they were maybe a little less culpable. So he's already done that. So if the case against him is not totally based on his statement to Virginia police, then the cat is really not out of the bag. With respect to the excited utterance statement, the Commonwealth would submit that I think this case is quite unique in the fact that Ms. Fisher was on the ground for 12 hours in her home, that the attack had taken place, and that the her nurse did not come for 12 hours. But I think that we would see this as an ongoing event where the lights had been turned off, the phones had been disabled, the cell phones had been stolen, and her husband was deceased right next to her. She was on the floor, paralyzed, and then she went onto the porch and then back. She's got a blanket over her. It's obviously cold in the house. And so when the nurse fortunately comes, because she had an appointment to come, and Ms. Fisher says, "Cindy, is that you? Invasion ambulance," and then some other statements, that is certainly said under the influence of the exciting event. I don't think that the event had ended for Ms. Fisher because she hadn't received any help and she didn't know if she
So
would
is that the
receive help.
test for excited utterance that you want us to adopt, whether or not the victim has received help?
Well, I think the test is still whether she was under the influence of the exciting event.
And are you aware of any cases that hold 12 hours later, half a day later, that is an excited utterance?
I think you could have 11 hours, and again, 12 hours obviously is a long time. But I think in the very unique circumstances of this case, I don't think that the time really matters in this particular case.
But that's why I'm asking for the test that you're proposing.
I don't think the test necessarily means when you get help, because sometimes you could not need that much help. But this lady obviously did, given the nature of her injuries, the severity of her injuries, and everything else that was going on with her. So in this particular case, I think that does matter. And that also goes to whether the statement is testimonial. You look at the severity of the injuries, whether we know where the perpetrator is, and she doesn't know that. And so I think, to whom the statement was made, it was made to her care provider. So those would all go in favor of the statement being non-testimonial. And then I think as Justice Georges indicates, she's fighting for her life. She's not trying to make a statement against anyone in particular, preserving her testimony at this point. That's what I would submit in this particular case. She's making it to her healthcare provider, and also I would say the statement is not very prejudicial to the defendant. She says there's an invasion. That's obvious, given all the physical evidence, forensic evidence, and then she asked for the ambulance. She says she's dragged herself onto the porch. She said that they tried to kill her, but that's obvious as well. And she says that she's tough, so it's not particularly prejudicial. But the Commonwealth would submit that it was properly admitted, as Judge Agostini found after allowing the motion in limine. If there are no further questions, the Commonwealth would rest.